Section 23, admission made upon express condition that evidence of it is not to be given. Where the admission is made under an express or implied agreement that the evidence of the admission shall not be given in any civil case which may be instituted or which may be pending against the party making admission. Such evidence of admission is barred by Section 23. Explanation to Section 23 provides that nothing in Section 23 shall be taken to exempt any barrister, pleader, attorney or vakil from giving evidence of any matter of which he may be compelled to give evidence under Section 126. Similarly, Section 81 of the Arbitration and Conciliation Act of 1996 exclude certain statements and admissions made by the parties to a conciliation proceeding from being proven in a civil cases and arbitration proceeding. Following are the essential ingredients in order to gain protection under Section 23. So there must be civil dispute between the parties. There must be negotiation between the parties or their agent with view to compromise. That negotiation must take place out of the court. For a promise, there must be express condition or circumstances from which the court can infer. Confession under Section 24 to 30. The term confession is not defined in the Evidence Act. However, it is dealt with from Section 24 to 30 of the Evidence Act and in Section 164, 281 and 463 in the Criminal Procedure Code 1973. Section 24 says that the confessional statement made an inadmissible. Similarly, Section 24 to 26 exclude evidence of confessional statement to the police officer. Section 27 deals with how much of the information received from the accused may be proved. Section 28 to 29 are in the nature of exception to Section 24. Section 30 deals with admissibility of confession of a co-accused jointly tried with the accused. The expression confession means statement made by an accused admitting his guilt. It is an admission or acknowledgement as to commission of an officer. If the person accused of an offense makes a statement given against himself, it is called confession or a confessional statement. According to Sir James Stephen, a confession made at any time by a person charged with a crime. Now coming to the case laws, in Pakala Narayan Swamy versus Emperor, AIR 1939, PC 47. In this case, the Lord Atkins stated that a confession must either admit in terms of the offence or at any rate substantially all the facts which constitute the offence. An admission of a gravely incriminating fact, even a conclusively incriminating fact, is not in itself a confession. Mix-up statement which, even though contains some of the confession statement, will still lead to acquittal is no confession. Thus, if the maker does not incriminate himself, the statement will not be a confession. Now coming to the other case, Nishikant Jha versus State of Bihar, 1959, SCR 1033. The court held there was nothing wrong in relying on a part of the confessional statement and rejecting the rest, and for this purpose the court drew support from English authorities. Under the English law, confession is not rejected only because of the exculpatory statement. Another case, Palvinder Kaur versus State of Punjab, AIR 1952, Supreme Court 354. Facts of this case were: the Palvinder was on trial for murder of her husband. The husband's body was recovered from a well. The post-mortem could not reveal whether the death was due to poisoning or what. In a statement to the court, she said that her husband, a photographer, used to keep handy photo developing material which is quick fission. That on the occasion he was ill and she bought him some medicine. That the fuel of medicine happened to be kept nearby the liquid. Developer and the husband, while going for the medicine, by mistake swallowed the developer and died. That she got afraid and with the help of the absconding accused packed the body in a trunk and disposed it into the well. The statement thus consisted of partly guilty and partly innocent remarks. It was held that a statement that contained a self-explanatory matter, example, killing done in a private defense, which, if true, would negative the offense, cannot amount to confession. That this is so because a confession must be accepted or rejected as a whole, and the court is not competent to accept only exculpatory part, that is self-incriminating, and reject exculpatory part, that is self-defense.